if a California association has not been enforcing and one day decides to enforce against you, especially if it's just against you, that's a big problem.
Yeah.
Right? Because they're going to run up with a statute of limitations issue, a waiver issue, right? They may have waived their right to go after you, but now we're in that selective enforcement territory. And that's really what you have to look at.
Yeah.
Are you being targeted? Are you being singled out? Are other people allowed to have these, features? And if not, if so, then the association might have a big problem here. Carlson, and for almost 2 decades, my law firm, LS Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of LS Carlson Law and host of Bad HOA. Welcome back. As usual, I have Marty, our producer.
Good afternoon.
Good to see you. Fun topic today, I think.
I think it's a great topic.
And this is a topic that we hear about over and over again. And it really is the heart of, I think, all bad HOAs, which is really the rules, the governance. Where do they come from? What is this, set of ways that a bad HOA can weaponize documents against homeowners? Where do they come from?
So the origin story of this episode has really come from our looking around at Reddit and the internet and what people are mainly outraged on. So it is fines.
Right.
Everyone is outraged about fines.
Well, I think rightfully so. And we said this before, that is such low-hanging fruit for a bad HOA to weaponize.
Yeah.
The fine structure.
Yeah.
Going after the homeowner. And sometimes when you pull things back, you start to realize, well, the fine in and of itself as written, maybe lack of due process, and we'll get into that.
Yeah.
It has no legal basis.
That's right.
And go ahead.
So when we were kind of peeling this back, I really wanted to set the stage of, well, what's enforceable? Because so many people I hear all the time. You see all over the internet, arbitrary fines. It's like, Can they do this? They just passed this rule. Can they do this?
Yep.
So there's a lot of uncertainty on how it's supposed to, when a rule can come into place, when you can find people on it. There's a lot of uncertainty there. And how would people know? They just bought a house. And I understand, like you get your house, you don't understand the nature of it. And guess what? A lot of times the board doesn't either.
Right.
So let's get into it let's start by a couple definitions.
Okay.
Because I think this is, for anyone that listened to the show more than once, we harp on a lot of different things: CC&Rs, bylaws, rules and regulations, and then also the hierarchy of the law, right? But I think it needs, for those that haven't listened to the show, just some real quick definitions, so they're not totally lost on.
I agree.
As we go through there.
All right, let's check them off. Yeah, because what we're really talking about is the set of documents that lay the foundation for an association and the governance.
And that comes down directly to fines, right? There's a through line all the way through.
Okay.
So let's talk about CC&Rs, and we should look at bylaws as well. Just lay a quick foundation in terms of what the definition is and what the difference is between the two real quick.
Yeah, when you look at CC&Rs, I think that's really the roles, obligations of the homeowners and of the board.
Yeah.
So in a very generic sense or a generalized sense, and again, California-centric, of course.
Yes.
You look at CC&Rs when you have questions about maintenance obligations or common area. Right? Who's to maintain this part of the community?
Yeah.
Whose obligations are, the exclusive use common area versus the common area that's free for everyone to use. I mean, this is where you find the definitions and the roles and responsibilities.
So I wrote down and maybe you have a different take on it, but I wrote down the constitution of the community, hard to amend, hard to amend, and controls property rights.
Yeah, very hard to amend, very hard to change. But yeah, I would say that it really is the cornerstone of the community.
Okay.
And it's really where you have a problem. A lot of the times, maybe 90% of the time, the board or the HOA is violating the actual CC&Rs.
Yeah.
And again, that comes from failure to maintain a common area. And often when there's a failure to maintain a common area, there's some sort of damage or intrusion that's happening. Yeah. So CC&Rs are a very powerful source of power, especially for the homeowner.
Yeah. And again, for those who haven't listened to the show, the one thing that we've said over and over and again is, and I didn't understand this either, but I always thought that the CC&Rs are always something that the homeowners, this is the thing that the rule that we have to abide by. This is the way we have to paint our fences, et cetera, et cetera, et cetera. I didn't realize that it gives you, the homeowner, a tremendous amount of power because it also defines what the HOA is responsible for. And to the extent that they don't, that's where you have a lot of power.
Yes. That is a common misconception. A lot of associations paint out the CC&Rs as this great power source for the association.
Yeah.
And to some extent, when the homeowners start to read the CC&Rs, they realize very quickly, whoa. The association is supposed to be doing a lot of things and they're not doing these things. Yeah. So that's a violation, that's a breach. And that's where you start to get these rights that you can then enforce vis-a-vis CC&Rs.
Yeah. Bylaws. I see so often online. I can't tell you how often I see that people use these two things interchangeably. All the time. My bylaws say this, but they are totally separate things. So what is the difference with the bylaws?
Yeah, if you want to look at bylaws as really the playbook for the board and how the board should function as an entity, right? So they're a little bit different, but in a very generalized sense, this is talking about elections, how meetings should be conducted. It's more of the governance of that body.
Yeah.
And that body is the board, right? Yeah. It's the members of the board. So they go to the bylaws to figure out exactly how meetings should be conducted, elections should be conducted. It's a little bit different than the CC&Rs in that sense, or a lot different, right? Yeah. So there's a big distinction between the two.
Yeah.
And often, like I said, the majority of violations come from a violation of the CC&Rs.
Yeah.
But it very well could be a violation of the bylaws as well, depending on what the actual malfeasance is.
Yeah, because that could go into fines, as we'll see.
Yes.
Later. Let's talk about, again, it bears repeating, the hierarchy of laws, because again, this will come into play if there's a potential conflict down the road. If your CC&R say one thing and later a law gets amended in the state of California, let's say, is that rule still applicable?
Yeah, which controls?
Yeah.
And that's a huge question. And that's a conflict of law, right?
Right.
And so, the bad HOAs will wrongfully say that the CC&Rs control, even though state law says something different.
Right.
But at the end of the day, it's state law.
Yeah. So let's talk about that hierarchy real quick for those who have not listened to the show again. We'll start at the top. And
very easy. You always start at federal level. Yeah. Federal is going to trump. Then you go to state.
Yeah.
And then you get into CC&Rs. And then I guess you get into sort of the rules and regulations. Yeah. And rules, what are we talking about? Rules. These are rules regarding maybe parking or the tennis courts or the pool, right? Yeah. And they're interesting, and we can talk more about it. But rules and regulations really need to be in line with the CC&Rs. Those cannot conflict.
Yeah.
And a lot of the problems that you see, especially with bad HOAs, is they will create a rule which is in direct conflict with the CC&Rs.
Yeah.
Which is just crazy. But they think they can get away with it.
Yeah.
Right.
So that's a whole nother topic, and I think we can streamline actually right into it. Is what is the difference between a rule and obviously the CC&Rs, and when does someone need to have a member vote versus a board only vote? Yeah,
you got to think of the CC&Rs and bylaws as these very fundamental legal obligations. So any changes there typically need some sort of supermajority vote. There's a due process. It is a huge deal, right, when it comes to a change or an amendment to the CC&Rs.
Yeah.
And I see the problems that happen is, the bad HOAs really don't understand that there has to be due process. There has to be notice. There's a notice requirement. There's a opportunity for the homeowners to speak up if they're against it.
Yeah.
And then it goes to vote. And typically, again, a lot of them are supermajority.
Yeah.
And it's a big deal when they fundamentally change a CC&R. Okay.
So, and I guess that goes back to the example of the Constitution. It takes a lot.
I like that analogy.
It takes a lot to amend the
Yes.
CCNRs.
Yes, it does, and it's a big deal. And if you have a board that's just doing it willy nilly, and you just get notified that, hey, we modified 4 sections of the CCNRs, that's a huge red flag.
Yeah.
Right. Because again, there has to be proper notice. There's a due process. There has to be this opportunity for the homeowners to speak up. Right.
Yeah.
So that's a big deal, which is different though than rules and regulations.
Sure.
We can get into that.
So CCNRs, we need in most cases a supermajority.
Yes.
We're talking broad strokes.
Very broad strokes. Yeah.
You need a supermajority. It has to be voted on by the members, aka the homeowners.
Yeah.
In order to change the CCNR. If a board member or the board itself tries to change a CCNR without that, they're not only breaking the bylaws, but often they're breaking the law.
They're in a world of hurt.
Yeah.
Okay. And that's a huge problem.
Yeah.
And if you find yourself in that situation, the homeowner's going to have a lot of rights.
Yeah.
You see what I'm saying?
Yeah.
State law wise, they're likely in violation of their own governing documents. I mean, it becomes a very problematic situation. But again, you need a homeowner who understands that.
Yeah.
And, we've been in situations where we're consulting with a homeowner, and this misbehavior or malfeasance has been going on for 5 years, 10 years.
Yeah.
No one called them on it because, Billy on the board says that they can do that. And no one called them out or checked or double checked or did the research. The homeowner wasn't empowered because they're like, well, he's been on the board for 5 years, so I guess he can just amend the CCNRs whenever he wants.
Yeah, the rights are only as good as if you're willing to enforce them.
Correct. Right. And so once you understand that, though, you should, whenever there's a amendment to the CCNRs, it should come under great scrutiny.
Yeah.
And really, that's what the law provides.
Yeah.
And you should have the ability to scrutinize it accordingly.
Yeah. And this goes to bylaws too. Those are harder to amend as well.
Those are fundamental core documents.
Yeah.
Right. And if you look at the CCNRs, bylaws carry such great weight.
Yeah.
Right.
And I could see that happening specifically in like elections.
Yeah.
Where the bylaws are crystal clear on how an election is supposed to take place.
Yep.
And the board does not follow it to the T. And therefore, how can you enforce? How can they do anything about it? But it's hard as a homeowner. This is a lot of nuance. I come back into this. The reason that we do this show is there's a lot of nuance here that the homeowner probably doesn't understand if they just bought a home and everything functions normally, and then when it goes bad, where do you go?
Right. And I think that the premise, really why we have this show in the first place, again, we always talk about empowerment, but once you get your head around these concepts, I don't think that they're overly complex. Now, historically, it's been a very complex world, very convoluted, right? The information was a little bit harder to analyze, dissect. It was harder to find a website that kind of broke out, what are bylaws, what are CCNRs?
Yeah.
But, with what we're doing, pushing this content out there, because it only doesn't come in the podcast form.
Yeah.
We do a lot of articles. And so, really the goal is once homeowners understand that, hey, the HOA can't just do whatever they want.
Yes.
And there's ramifications for that.
Yeah.
You start to shift the power dynamic pretty quickly.
Yeah.
And we've already seen that in California. We've heard on AB 130.
Yeah.
It's a really wonderful thing to see, because if you want to talk about being outraged, you talk about a bad HOA that messes with voting, that tampers with elections.
Yeah.
Right. That disregards the bylaws, that doesn't, that ignores the governing documents, and they just start doing things, shooting from the hip. I mean, that is outrageous conduct.
Yeah. And we've said it a million times, forgive us, but for those who haven't listened, I mean, these are people that get voted in. They're just your everyday homeowner. It's likely that it's possible they've never run a business, managed anything in their life, and now they're in charge of managing a community worth multiples of millions
sometimes
of dollars.
Hundreds of millions of dollars.
I know.
I think too, looking at it, you do have people who get on the board, and even if they don't have that management background, they're there in a very altruistic way. And, I somewhat, applaud them, because it's a very thankless job.
Yeah.
But they approach it in a way that they say, hey, I think I can do some good for the community.
Yeah.
But there are so many that we see that are there for very bad intentions, for
Yeah.
lack of a better word or
Yeah.
description. They want power. They want to meddle. They want to, capitalize, monetize off the position. And when that happens, that is when you have these really, really bad situations in associations.
Yeah, and then on the not so egregious, you just have ignorance, and like
Right.
you can state your favorite line about ignorance.
Well, yeah, no defense, right?
Yeah,
But I think on balance, if you do have a very ignorant board, at least I think there is an opportunity for the homeowners, and arguably or even a responsibility,
Yeah.
to educate the board, get them to
Yeah.
where they need to be.
Yeah.
And that is through open sessions, conversations with the board, and a good board will be receptive.
Yeah.
This isn't, it shouldn't be some sort of judgment on their character. It's,
Yeah.
hey, you simply don't understand CC&Rs. You don't understand bylaws. You in California, you don't understand the Davis-Sterling Act.
Yeah.
Okay, fine. That is what it is. Let's educate. Let's
Okay.
get them to where they need to be.
Yeah.
Versus the association, and we've seen this before, board members who don't care.
Yeah.
They know about the Davis-Sterling Act. They know about the CCNRs. They know about the bylaws. They just ignore those documents.
That to me is wild. Like they know it's there and they just flat out ignore it like they're above it.
Well,
but if they go unchecked, then
yeah, it works for them. And again, we've seen homeowners who come in 5 years unchecked power until we finally come in, and we come in guns blazing at that point because there's such a long paper trail of malfeasance.
yeah.
But again, it's all about enforcement.
Yeah.
And the goal, I guess the objective of this show is to empower homeowners to go after these bad HOAs.
Yeah.
To solve the problem.
Yeah. So we're going to put a button on it. CCNRs, bylaws, big change, like amending the Constitution needs, in most cases, supermajority means most of the homeowners have to vote on it and pass it. So that's a big deal.
Big deal.
So let's talk about when the board can act alone.
Well, often when you look at rules and regulations, now there's some variation on that, but for some sort of basic, let's say pool hours,
Yeah.
This low hanging fruit type of activity, generally okay. The danger there, though, and this is where it becomes problematic, is the board has certain rights to act sua sponte, sort of on their own. They think that the pool hours should be this, or their parking should be this, but they do it to punish or to target a group or an individual. And so rules and regulations historically have been highly weaponized. And I've seen it. They don't like Sally. So what do they do to Sally? They carve out very specific rules where now they can fine her for some sort of behavior.
Yeah.
Right. And so you got to be very careful with that. Because that in and of itself becomes, a breach of fiduciary, violation of state law. I mean, it becomes very problematic for the board, but you do see that behavior.
Yeah. And there's lots. We have written down here. This is a chunky episode. I took lots of notes on this one. So I wrote parking, pool hours, trash collection, pet registration. There's a lot of things where the board can act.
Yeah.
And then, there's things that they have to do too, like landscaping contracts, repairs, repainting, architectural approvals, assuming they fall within the standard of the CCNRs.
And you have to look at it as sort of, again, you look at the foundational document, which is CCNRs and bylaws.
Yeah.
And that's the prism that you're looking at these rules and regulations.
Yeah.
And if these rules and regulations are inconsistent with the CCNRs, then you have a problem. There's a problem with the rules and regulations. Likely they're unenforceable.
Yeah.
Right.
Yeah. So I also put a button on this that says, if it affects your wallet or property rights, members must vote. If it's daily operations, the board can act, but only if they follow the law and the CCNRs.
Now, that might be a general good rule of thumb.
Yeah.
With some exceptions.
Yeah,
As
of course.
lawyers, there's always exceptions, but generally speaking, that might be okay.
Yeah. Okay. So that doesn't mean, though, that a board can just come up with an arbitrary rule on their own. Isn't there like noticing periods and things that they have to?
There typically is, and you look at the governing documents for that.
Okay.
And really what we're looking at here is that targeted set of rules and regulations. That becomes, for lack of a better word, this is where a bad HOA starts to weaponize their role.
Yeah.
And that's where we see very select sets of enforcement.
Yeah.
Because they say, you know what? I know that this person parks here. Let's say they can't park there now. They have no other reason
Yeah.
to enact that rule
Yeah.
other than to harass, target this one homeowner.
Yeah.
And that's where it becomes very problematic from a legal perspective for the board. But they do it routinely. I mean, you see it routinely.
Is it even just, let me ask you this, even with just a rule, let's just say that they change the pickleball court from it ends, typically it closes at 7 and now they're pushing it to 10. Okay. Are they required to give the homeowners notice saying, hey, this is we are planning on changing the rules, and give them some sort of a period where they can say, they can hear them out and then they finalize it?
It depends on the community. You got to look at the governing documents, and it depends on what they're trying to change. So it is case by case. Some things they can just sort of do unilaterally. Other things that have more of an impact on the community, there might be a notice period. The due process might be a little bit different. So it is case by case.
Okay.
But, I think you always look at impact. How great of an impact is it? That typically sort of coincides with the level of due process, notice periods, and, whether or not the homeowners will have a platform to speak up against it.
Yeah.
Right. You're looking at impact.
And then, I mean, you have on the opposite end of the spectrum, you've got, I see it online all the time, for people that they haven't enforced a rule in a decade.
Oh, I love these.
You know what I mean?
Yeah.
And then all of a sudden now they're enforcing, but they're just enforcing on me.
Yeah. So that raises a host of issues. And typically what you see is a rule or regulation that's open and obvious and people are violating left and right.
Yeah.
And typically it might be a paint color or some sort of architectural feature.
Yeah.
And it's something that everyone sees, but no one has enforced.
Yeah.
Let's say for a very long period of time. Let's say 5 years. And all of a sudden, this homeowner they fall out of favor with the board. And the board says, you know what? We're going to go after you now for this.
Yeah.
And they start finding, they start enforcing. And they say, hey, this is a violation of the CC&Rs.
Yeah.
But it's been over 5 years. The board is going to have trouble really enforcing that for a number of reasons. It could, this notion of statute of limitations. They have a certain amount of time to enforce their rights. And if you don't enforce within a certain amount of time, you waive the right to enforce. You might be looking at selective enforcement. And this is a big one, right? If other homeowners are doing something that you're doing, but you're the only one being targeted, that becomes problematic. Yeah. And another way of saying selective enforcement too is preferential treatment.
Yes.
Right? Because the other side of the coin is, hey, 10 homeowners are not getting any violations. So their treatment is preferred.
Yeah.
I'm getting the violation notice. Why me? So that's the selective enforcement part.
Yeah.
So that becomes problematic, right? There has to be an equal application of these rules.
Yeah. And
they have to do it in a timely fashion. They can't just sit on their hands for 20 years and say, you know what, Barbara, you can't have that.
What about when you have, for instance, a board, we just elected a new board. New board comes in and they read the rules and say, oh, we were not supposed to be painting all of the fences like this, and third of the homeowners have. Can they go back retroactively at that point, even though it's been that way for 10 years, let's just say? And
it depends. It depends.
Oh, another famous lawyer.
It's a famous one.
Word.
It depends. I mean, what you're looking at there is an equal application of the rule.
Yeah.
It has to be uniform, and there's some other things to consider, but that might be permitted in certain circumstances. Yes. But again, where we see the issue is the enforcement is not equal in its application. That's one of the biggest, I think, telltale sign of a bad HOA is when it's unequal application and enforcement. And sometimes it's bizarre. You see, it's not only targeting one person, but it might be a group. Yeah. A group of homeowners that, the board, for whatever reason, just doesn't like. And so you're always looking at, how is the board enforcing? What is the scope of the enforcement? Is it 100%? Yeah. Or is it 20%? Yeah. Right. And that's where the board can get into trouble.
We saw Reddit, a post that we talked about on a previous episode where people were putting up political signs, and all of a sudden they were supposed to take them down, but another set from the other side of the aisle, those were they were allowed to be up there. Yeah. So it becomes,
it becomes very interesting. But often it's driven by just a bad actor.
Yeah.
Someone on the board who is
Yep.
trying to silence somebody, likes a certain group, dislikes another group,
Yep.
and is abusing the power of the board.
Yeah.
That's where they get into troubled waters very quickly.
Now, we touched upon it just briefly at the beginning of the episode, but state laws versus your CC&Rs and the HOA rules,
Yeah.
right? In California, we have changed a lot of things, and some of these HOAs are older. And maybe not even that old. They could be an HOA that's 5 years old, and there's very specific that you have to have this type of lawn, and it has to be maintained.
Right.
And all of a sudden, California takes this drought tolerant posture and says no. They become in conflict,
Yes.
right? So where a board is trying to enforce a certain rule, clear in the CC&R, there might be a specific rule. But now the law had changed.
Right.
Who wins in that scenario?
Yeah. Well, you're going to defer to state.
Yeah.
And we saw that with the drought. We saw that with solar. And you see it in a number of other areas. But you have this provision in the CCNRs that they say, all grass needs to be luscious and green. Right. I don't know if that's the exact
whatever
that means, right? Yeah. Well-watered lawns, well-maintained, well-manicured. And we're in the middle of a drought.
Yeah.
And there's emergency legislation that comes into play. And it says, hey, we actually don't want this. This is against policy in California.
Yep.
And all of a sudden, the board, though, is still enforcing this luxurious lawn scenario.
Yeah.
That's not going to win. But it might be a lack of education. The board may not know about the emergency law that came into play. It could be a number of things. It doesn't matter.
Yeah.
Right? The homeowner has a right to push back and push back aggressively on this.
Yeah.
And so you're going to have a state that's going to win every time.
So in a lot of situations, it's the board is either ignorant or
a lot of the time on those scenarios, it typically is ignorance.
Yeah.
They just simply don't know. They don't know how the two compete.
Yeah.
Which is terrifying in my mind that, you're in a position where you're enforcing rules and regulations and you don't know sort of the difference between the two, but fine. That's okay. But once you're alerted of it, once you're informed, once you're educated, okay, adopt that position. And if you don't know, if you're on the board and you still don't agree with the homeowner, go to your counsel, go to your attorney. You should have counsel. And if it's competent, hopefully it is, they will explain the law to you, right?
Yeah.
Do your due diligence.
At that point, do they amend the CC&Rs? And then to the extent that they do, I would assume that you're supposed to notify and provide the homeowners a new set of the most recent.
Sometimes
CC&Rs.
they'll be very proactive and they'll amend and make them consistent.
In that case, it's amended. Can that be amended with? Obviously, it doesn't need a homeowner's vote because it's totally now not within the realm of the law.
Often what happens though is I don't see that sort of reaction from HOAs.
Okay.
It's an antiquated provision in the CCNRs because you have to remember the other side of it too. To amend the CCNRs, it's still a process and it costs money.
Yeah.
And you have to understand too, that's why you see sometimes, homeowners come in and their CCNRs were drafted in the 1983.
Yeah.
Very old, antiquated. Well, a lot of what's in there is simply supplemented by the Davis-Sterling Act. Right? Yeah. So when something is in conflict with state will override. So you kind of go to the Davis-Sterling Act as the auxiliary set of laws.
Yeah.
And, I think some HOAs do their best to stay current. A lot don't.
Yeah.
But just because they don't doesn't mean that the state law doesn't, prevail.
Yeah.
Right.
It becomes really hard as a homeowner that's buying in a community that they read the CC&Rs and they
it can be, yeah.
And then they they were drafted in the
83.
83
on a typewriter.
Are you calling me old?
Well, I'm older than you.
They look at the CC&Rs, but they're not in, you have to know if are these, in lock in step with the California rules and state laws. That becomes an issue. It becomes almost a little frightening to some extent.
I'll acknowledge that it's not super user friendly.
Yeah.
You know what I mean?
Yeah.
I think as a homeowner, you look at the CCNRs, you do your best to decode it. If they're old, antiquated, you go to the Davis Sterling Act.
Yeah.
Try to get your head around that. And if you simply cannot put these things together, talk to a lawyer.
Yeah.
Carve out an hour with a lawyer. And a good lawyer who understands the space should be able to go in pretty quickly and articulate your legal rights and obligations.
Yeah. All right. Let's jump into,
What do we got?
I think we covered that really well. I just want to, there were some interesting things that came out this, the last actually September of 2025, which is the census data, which is really interesting to me. And it just shows, I think, the importance of homeowner education is that according to U.S. Census data, 1 in 4 homeowners, 1 in 4 homes are within an HOA now.
Yeah.
It's a huge amount.
I believe that.
It's a huge amount. And a couple of interesting notes too. According to census data, 3 million households pay over $500 a month. The median is $190 a month. The Northeast is the highest median. The South is the lowest. And then the older communities typically have higher fees.
Yeah.
So it's really interesting to see. That John Oliver story came out that I think 83% of all new homes are in don't quote me, it's either 83 or 87, something. I know it was in the 80s.
Someone's going to quote you in the
it's
comments.
Fine. That 83, 87% of new homes are in HOAs.
Yeah. Well, if you think about it, cities are incentivized to offset that economic burden.
Shameless plug for the last episode here.
I know, right? But that's true. And that's why you see that. And I don't think it's going away, honestly.
Yeah.
And I think all the more reasons that homeowners who live in these HOAs, which is a lot, 1 in 4 1 in 4.
Yeah.
What is that? 21.6 million?
Yeah.
Yeah. You need some education there. If you live in a homeowner association, hopefully it's a good one.
Yeah.
Right. But if it's not, or just basic education.
Yeah.
Not a bad idea.
Yeah.
Understand what CCNRs are, understand bylaws, keep an eye out for things that might be red flags.
Yeah.
And, hopefully if you can empower enough homeowners, you stop seeing the bad HOAs.
Yeah. And this number is going to grow.
Exactly.
It's going to grow. I mean, next census, it could be 1 in 3. I mean, if we continue to build and if the number that John Oliver gave is correct, that this number is going to grow. So all the more reason. And we've talked a lot about reform and we're big, proponents of it.
We got some exciting things coming down the pipeline with reform.
Yeah.
We got some big trips.
I know. The Sacramento wasn't the first, we said.
Nope, not at all.
And
not by a long shot.
Yeah. And won't be the last.
Nope.
Shameless tease here.
Yep.
Okay. Another thing. Interesting. Utah came out with a new office that just oversees HOAs, registry advisory opinions, homeowner education. That's a big deal.
Yeah, these are actually not atypical. They are in a handful of states, and I think they're interesting. That we don't have them in California, right? So I don't fully understand everything about them. Why would I? It doesn't impact really what we do in a lot of ways, but I don't think it's a bad move. The issue, though, is at the end of the day, they don't have the force of a court of law. Right? And so
it'd be interesting to see, though, because I think a lot of homeowners, again, I've seen just on various subs, a lot of homeowners feel like they've got no, where do I go to?
Right.
That's outside of the legal process. Where's the Better Business Bureau of HOAs? Who can I go to complain about this situation or whatever? They feel like they've got no recourse except the legal route. To that extent, I feel like that's, again, I don't know too much about this. I think it's interesting. And it just shows that going back to California, AB 130, going to Florida and the massive amount of reform that happened there post Surfside, it just shows that a lot of people are becoming more educated and states are taking notice and trying to put in certain guardrails in place to lower the amount of issues that people are having with these
You know, the
HOAs.
more enforcement, the better. The more accountability, the better. I think the more liability for bad HOAs, the better.
Yeah.
You know, we're trying to stop a massive problem in the U.S., in California and Florida, and throughout the U.S. I mean, these are steps in the right direction.
Yeah.
So,
all right. Last but certainly not least, let's cover a Reddit story.
all right.
I know it's one of your favorite
Maybe
things.
you read it, and I'll read it as well.
Okay.
Put on my reading glasses.
Oh, there you go. Okay. And this goes back to what we kind of spoke on this, but I'm going to read it anyway. HOA suddenly, let me slow down. HOA suddenly enforcing rules after years of not. Moved into my community 3 years ago. The HOA apparently had not enforced rules in years and years. Suddenly today, an email went out with photographs of individual townhomes, citing them as examples of rules that will be enforced moving forward. Most of the photos are townhomes that have plants and planters and plants hanging from awnings, all of which was previously ignored/allowed despite being against the rules. Nothing has been enforced in 10 plus years. What recourse do we have? And that's basically the there and a few other choice words because they were upset.
Yep, very upset. But yeah, kind of going back to my original position, you know, at a certain point, the association begins to waive their right to go after homeowners for violations. And it is a case-by-case scenario. Now, if this, and again, this isn't legal advice, we have to say that.
Yeah.
This is general observations, if anything. But, you know, if a California association has not been enforcing and one day decides to enforce against you, especially if it's just against you, that's a big problem.
Yeah.
Right? Because they're going to run up with a statute of limitations issue, a waiver issue, right? They may have waived their right to go after you, but now we're in that selective enforcement territory. And that's really what you have to look at.
Yeah.
Are you being targeted? Are you being singled out? Are other people allowed to have these, you know, features? And if not, or I'm sorry, if so, then the association might have a big problem here. And so I think this would be a very interesting one to look at, especially if we talk to other homeowners and the other homeowners are saying, yeah, no one's bothering us about this. And this one homeowner in particular is the target of this enforcement effort.
Let's just say, go back to the example I gave earlier. What happens? The new board just comes in and says, oh my goodness, we're supposed to be enforcing. There's a rule in here that we're supposed to be enforcing. And a third of the homeowners are not abiding by the rules. But I think it's our obligation as the board to fulfill the rules. Yeah,
they might be able to do so. If it's a new board, under certain circumstances, that would be permitted. Although at the same time, it's possible that a legal argument could be made that the board waived that right by not enforcing. There's a certain period of time, you know, and what are they at?
They said
10 years plus.
Yeah.
You know, it's tough to come in and start enforcing something that you haven't done historically. So again, it is case by case. So to have to come under a certain legal scrutiny. But I think the board, you know, if they don't enforce something for a very long period of time that's open and obvious, it's much more challenging for them now to step in and sort of ramp up enforcement efforts. Not saying it's impossible, but it can be problematic.
I feel like so many of these issues can just be solved with open dialogue.
I agree.
You know what I mean? If the board literally says, you know, this was a rule that was in play that's supposed to be in place. We recognize that a third has them. We want to have an open dialogue on whether or not this, you know, we want to enforce this or set it aside, which I think can be problematic too if it's in the CCNRs versus being a rule.
Well, back to this. I think that goes back to a basic premise, though. Typically, the bad HOAs aren't reasonable, and you don't have that dialogue.
Sure.
Right? And this law firm, as lawyers, we don't really hear about the stories that go well.
Yeah.
You know, I think a lot of HOAs do have open dialogue, and they work, they function, they're healthy, they're transparent, they explain why, they work with homeowners. They don't immediately go to fines and they don't weaponize their lawyers.
Yeah.
They work collectively.
Yeah.
We don't hear about that.
Yeah.
We see it when it goes bad. And when it goes bad, it's because there is no communication. There is no dialogue. The board is acting on its own accord. It's weaponizing these rules and regulations. It's going back and it's trying to target people for rules that they've never enforced historically.
Yeah.
These are where the problems come from.
Yeah.
And, you know, if anything from this episode, homeowners really have to understand they have rights, and those rights come from those governing documents.
Yeah.
I mean, that's it, right?
Yeah.
So,
okay. That was a lot of content.
that was good. Yes,
Yeah.
I felt very good about this one.
There's a lot of stuff here, and I hope that it really paints a picture, because it can get, like I said, I think it can get complicated.
I agree. But if anything, don't get overwhelmed. Embrace those CCNRs, embrace those documents, read them.
Yeah, so many comes back to just read your CCNRs, read your bylaws, and half of the issues can probably be solved just by you reading those things right there.
Agreed. All right. So thank you for watching. Again, like, subscribe, leave comments. We love all of that. And until next time.